Hi, friends. We're going to be resuming here in just a few minutes, so if you'll go ahead and kind of pack up and get ready to take your seats again, we're about to get started with our second panel. Thank you. Welcome back, my friends. I hope you had some good conversations over lunch and have enjoyed the opportunity to kind of process all of this new information with some of your friends today. It's been really fun for us to kind of unpack some of this, and now we are really looking forward to panel 2 for today. This next section is going to kind of lean into the idea of justice or algorithm, and we are going to explore AI's role in the public legal sphere. This panel will explore AI as it relates to fairness and cognitive diversity, the case for using AI as co-counsel in self-represented litigation, and how we tackle and limit AI bias as it pertains to the law. Here to guide us through this discussion as our moderator is Honorable Scott Schlegel. Please welcome him back to the stage.
All right, well, y'all can join me. All right, I'm going to flip hats here and become the moderator. And I'm excited to get into this because we've heard about AI and AI. But, you know, we're going to start learning about how it could possibly, you know, has it cracked the code for access to justice? And if it's cracked the code, what are we going to do about privacy and bias? So we're going to have three experts here that I will introduce and jump into it. Kirsten Suberg is the president and CEO of Disability Rights Ohio and a Fellows Class of 2020. She has a wealth of experience in empowering and advocating alongside people with disabilities. She's also worked as a judicial clerk in the United States District Court for the Southern District of Ohio, represented clients in all stages of the litigation and appellate process, and served as an adjunct professor at the Moritz College of Law. Welcome, Kirsten. Susan Shea, Executive Director of Ohio Legal Help. I can't wait to hear what you have to say about SRLs and how this is going to work out. A Fellows Class of 2016 and OSBF Trustee. Ohio Legal Help is a statewide legal help portal recognized as a national model for empowering people to resolve their legal disputes. She previously served as Section Chief of the Civil Rights and Consumer Protection Sections at the Office of the Ohio Attorney General and as a clinical faculty at the Moritz College of Law. Should I go to this school? I mean, this is everybody's, you know, professor here. And Susan began her career as a fellow at Advocates for Basic Legal Equality and has brought her passion for promoting justice to every role, expanding access to legal help across Ohio. Please help me welcome Susan. And finally, Mehmet Munur, partner of Taft Law. In his current practice, Mehmet is focused on information privacy and security, technology, and financial services regulation. He's also a trusted advisor and speaker in the realm of emerging technology, including AI, automation, and more. Welcome, Mehmet. All right, Susan, so I'm going to start with you. Has AI cracked the A to J code, and can it help close the justice gap? Small question to start us off.
Well, easy question for me to start off with. I think it's going to be a game changer just in the way that technology has been a game changer for self-represented litigants. I want to go back to something, Sadie, who's in the front row, and she was talking about DR courts, for instance. And I know for the DR judges and for the juvenile judges and for certainly municipal court judges, I think it's always been the year of the pro se plaintiff. I think the statistics are that nearly 60 or 70% of folks that come into a DR court are unrepresented. So I think AI can be a game changer, but I think we need to be cautious because I know just from our data on our website that most folks actually start with Google Gemini and get to us, right? Most folks start at ChatGPT then and get to us. So even before they get to us, they're putting their query into generative AI, getting an answer, and then saying, okay, I need to find out more. That's great. When they stop going, I need to find out more, and they stick with just chat, and chat starts to generate pleadings, I think that's where it could become co-counsel. I like to think of it more as an assistant, but when it becomes co-counsel, that's when I think things can, I'm just going to be kind, go off the rails. But I think it can make a huge difference in terms of self-represented litigants getting the help and the direction to a good resource like a court or like to our website. So yeah, we're embracing it for now.
For now. And how is this different, if you will, when SRL started going through the self-step forms that we started building for them?
So unfortunately, I'm always auditing ChatGPT, and we have Claude as well. And right now, we're using Claude for some application that we'll be launching. It is different. So where ChatGPT is now, and depending on the level of, let's say, depending on the level of service you're purchasing, ChatGPT now will guide you actually in filling out forms. Not well, but it can guide you. I mean, it might get to a point where it's better, but if you ask it, I need to get a divorce in Ohio, for instance, it's actually sending them to our site because we actually have like that kind of step-by-step. You fill in facts, and then we fill in the right fact to the right part on the uniform form or the local form. What ChatGPT does is it's going to take all of its training and learning, it's going to secure the form, usually on the court website, and then it will say, okay, what's your name? And it can actually guide you, but it depends on the form. Claude can do different things, but it's not the same as, I would say, what we currently provide, which is plain language, 4th to 6th grade level, and ChatGPT will also attempt to translate if you ask it to, and that can also go off the rails. And I'll just give you an example. So I'm going to say Spanish is pretty good. It just is. There's so much training data, it's very good. Somali, for instance, which here in Columbus, we have a significant Somali population, right? If you put in, we actually hand review our stuff, so we had a thing on custody. We have an article on custody, right, which we had translated. We'll do machine language first, and then we'll review it. It translated custody to like somebody who's in jail, right? Completely different. We're not talking about putting a child into jail, right? But that's where, even with that kind of contextual, it can go off the rails. And so, but I will say it's better now than 2 years ago. Like 2 years ago, if you asked it to fill out a form, it would just say, forms are here. Now, if you ask it to fill out a form, it's going to try very poorly to help you. So I think that's kind of what I'm seeing right now in all the different engines.
That's great. Sherston, how are people with disabilities leveraging AI, and do you think it's cracked the code for increasing access and inclusion?
I think it is like, it's going to be the same issues as we've raised everywhere else, right? It's going to be an it depends, and it can only be as good as the information and the accessibility that we build into it as we go along, right? I do think it's interesting, though, how many people here use Alexa? Not very many. Well, how about Siri? Or something like that. Okay. I mean, those are things, there's common technology we use right now. But decades ago, that kind of voice to text, that was an assistive technology development for people with disabilities that's now become like a universal design technology thing, where you can take an off-the-shelf item to do what had to be specially designed in the past. And I see similar types of things like that could happen with generative AI in the future, as long as we're building in accessibility. So I always, our philosophy at my organization is we really want to tap into the disability community. It's not about us, it's about, what their experience is. So in getting ready for this panel, that's what I did. I talked to professionals, I talked to disabled advocates, I talked to organizations, and some of the things that they told me that were sort of on the fringes, that were starting to happen, that we're building in generative AI, not just the smart tools that we had before, going a little bit beyond AI to generative AI, was Alexa getting to a new level of not just answering a simple question like, hey, what's the weather like today, but helping with decision making. What should I wear for this weather? And that could be really important for someone with a cognitive disability that maybe does struggle with deciding what's appropriate attire to go outside, and they can be more independent, which is great for them as a person, but also great for our service system that is vastly underfunded and has a lot of struggle to meet that demand. So that was an example that was brought. Other, just even being able to have more conversational kind of discussions about, not just turn the oven on to this temperature, but I want to bake X, and helping start thinking about walking through that. It's not quite there yet. There's still, there still could be problems, but those are the places where they're starting to see some advances. Another example was, autistic children that might struggle with transitions, and not just prompting them with an instruction, but using things that were adapted to them to give them a transition cue, like a quote from their favorite book or something like that. And again, not all of this is necessarily tapping into all of the things of generative AI that we've talked about today, but it will further develop as it taps into that going forward. There's definitely opportunities to go beyond that. And the last one I want to share, because it does raise an interesting ethics question too, that could impact in the law as well, is as we get better with things like having a voice, right? A voice that sounds like a real human. You call customer service and you think you're talking to a human. Many of us know we're not because we're kind of accepting that that's the reality today. But there's a thing called remote support. It's already in the disability service space where you might have a person reach out and have a phone call with someone, or they might have video camera access that just turns on when they want it to. It's things like that, so that you don't have to have a person in the home to provide that more intermittent support someone might need. Well, they're looking into enhancing that to be, again, more conversational, where instead of a person calling, it is a bot calling, right? But it's so conversational that is it going to deceive the person on the other end into thinking it's a human, and is there an ethics issue there, particularly if you intersect that with a disability where there may really be a deceptive practice that you're not going to be intending, but it's happening.
That's great. And Mehmet, with all of these private information being shared, what issues regarding privacy and security do you see coming up, and where are we today?
I think AI amplifies the kind of privacy security issues that we face in society. Earlier we were talking about AI deepfakes. I think we will continue to see an increase in the number of unauthorized access to data and fraudulent activities. And it's surprising in the way that impacts even people who are familiar in this area. I'm not going to sit here and tell you that I fell victim to one of these. Thankfully, I haven't. But the way in which some of these issues arise sometimes is surprising. You end up getting a call from somebody who you think is a family member with a voice that resembles exactly them in the middle of the night, telling you that they're in need of money to pay off a bail. And then next thing you know, you're finding yourself sending money so that you can release a family member from jail, essentially, because that's in the moment, everything seems so real, right? Those kind of items are increasing. And phishing, spear phishing activities, the kind of unauthorized access to data and funds is becoming more and more sophisticated. Just the other day, I received an email from a fictional company telling me that they had had a data breach and they were in need of a counsel. And I had to maybe spend about 10, 15 minutes before I made a fool out of myself by calling these people and falling victim to their scheme, essentially, to realize that these people didn't really exist. The company that they were talking about maybe had an address, but it wasn't the company that would have had this particular legal issue. And the following day, I get a call from them. Now, there's a possibility this company is real, right? But I'm not willing to take that risk because I don't want to make a fool out of myself as a data privacy, data security technology attorney who should know better than essentially falling victim to these. And there are so many individuals here in the United States, elsewhere in the world, who are falling victim to fraud. And it's not just individuals, it's also businesses as well, because now it is so much easier to essentially fool somebody into believing that they're dealing with an actual human being. Introduce other data privacy, data security risks into the interactions that you would have with these individuals, then essentially you find yourself in conversations where you think you're talking to a supplier, talking to a bank, talking to a title company. As it turns out, they're all the same people. It's just the hackers that are fooling you into sending the money where you shouldn't. And these kind of facts and errors come up more often than you would think, and people are losing a lot of money as a result of it, and you end up getting a lot of litigation afterwards, arguing, well, you had a duty to ensure that essentially that you didn't introduce these unauthorized hackers, or what is the entry point with respect to the hackers when they started accessing this. The use of AI ends up making it so much easier to gain unauthorized access to a system, and it's essentially a force multiplier. Thankfully, it's a force multiplier not just for the hackers, but also for the defenders. But it's making things both difficult and more expensive to deal with in the long run. The other item that is worthwhile, I think, thinking about is maybe not just so much in the unauthorized access to data space, but with respect to use of technology. AI, as we talk about, large language models, whatever you want to call them, are just a tool. And tools can be used for good or evil, and it depends on how you use it. And if you don't realize that you are providing your data to a system that is training on it, then you may find yourself waiving attorney-client privilege, right? Because maybe you didn't pay for that. Or at the same time, disclosing personal information of your customers or others to a company that shouldn't have had it in the first place. Now you had a data breach, and you got to disclose that, right? You got to send data breach notices to individuals, and I'm sure all of you have gotten one. So essentially, it ends up creating risks that end up impacting, increasing the kind of risks that we have usually with respect to data privacy and data security in society.
And Susan, with all of that said, what are some other opportunities and risks for self-represented litigants using AI?
So I want to pick up a little bit on the privacy thing because I think that's critically important. We really think that that's a best practice for any tool that we build, but I think that having worked now with millions of the consumers who come to my portal, I shouldn't call it my portal, sorry, our portal, it surprises me how much information, even when you specifically ask them not to give you that information, that they will want to share with a website, a portal, an agent, because they feel that it's this very private relationship. So that's one of the things we try to educate folks on is, especially like, unfortunately, one of the most accessed pages on our site is on protection orders, right? So especially for individuals who are survivors of domestic violence, we try to make sure that they understand all the best practices around data privacy, right? It's important that they're not tracked, that they're not sharing too much, that they're not, and so just kind of thinking privacy that way. But then as an organization, we have to be really careful with our users' privacy as well. So we're getting ready to deploy, while we're using Claude actually for this, we're asking folks to give us, and obviously lots of waivers here, but people will sign pretty much anything. We're asking folks to share with us their driver's license record, which is the informal driver's license record that they can get from the BMV. For folks who are kind of aware of this, there's a little over 8 million drivers. At any given time, 1 million are on a suspended license. Yeah. So, and it's a huge economic workforce issue, right? And it's not because that they were suspended because they, well, some of them, but not all of them, because they were not driving well, or, it's because, they didn't show up for a traffic day, there's a warrant block, they got a license suspension forfeiture, because maybe they couldn't get off work that day, right? They couldn't get off work that day, they get the warrant block, and they're just like, well, what do I do, right? They drive again, because they have to get to work, they get another. So what we did was we created a tool that will actually take that driver's license record, and we're using AI to then analyze it and what we call organize all that data into the right buckets, and then we're running a good old-fashioned algorithm to give them the steps of how to take care of those issues. When they share that driver's license record with us, sometimes it has their name, sometimes it has other data, right? And so we need to think about that, like in terms of how we take that data off so that we're only sending what we need to the AI to analyze to send it back to us. Because we know that our users will waive everything and say, no, it's fine. So we have to be thinking and be protective. But at the same time, I think we have a duty to educate on this, especially with respect to self-represented litigants. Does that answer your question? Sorry.
Oh, no, we're good. You're doing great. Keep going.
Okay. I guess
the real question is, obviously there's a lot of potential benefits, but obviously a lot of potential concerns. And so from your perspective, what are the ones that just jump out at you as, best use case, worst use case?
So we thought a lot about the driver's license because it's on the data privacy, I'd say medium risk, right? But at the same time, we can scale something that before couldn't be scaled before because 1 million folks come to our site, right? Now we can get out basically that organization, that action plan, that next steps. This is how you take care of a warrant block. We remove that fear, right? So to us, that's an amazing benefit that AI provided to us, and yet we can mitigate risk. And so that's kind of I hope that's the way folks are thinking when they apply AI, but that's not. A lot of folks will sell products that say, just trust us, you don't need an attorney, we're going to be your counsel, but we're not committing UPL because you're going to make all the decisions, right? But they don't really understand what that motion's for, right? They fill it out because they're not getting the context, and so then you'll have cases like There was a recent case that was filed, actually just March. Judge, I'm sure you're aware of this case. And it's Nippon Insurance. And basically, that was where AI was co-counsel, right? That's where ChatGPT, we'll see what the case says, I think went off the rails. Because if you use ChatGPT, your ChatGPT loves you, right? You're always right, even when you're wrong, right? And ChatGPT is always right, even though it's wrong, right? And that's where the danger is with self-represented litigants. Because I think, and Judge, I think you speak to this, people always talk about human review. Well, it depends on who that human is, right? And so I think, especially as a technologist, I have to be really thoughtful. I have to actually want to protect their privacy more than they want to protect it. I have to think about, how is this tool going to be utilized? What are the dangers? How do we mitigate that? And then I have to think about, what's the benefit, right? Because we're not thinking about money. We're thinking about, what is the benefit? How are we fulfilling our mission to close that access to justice gap? But not all providers are doing that. So you can get providers who are saying to self-represented litigants, you know what, just buy this, it's $50, it'll take care of all your problems, right? Or ChatGPT will say, for this subscription price, we'll give you all of this. But I think without that real thoughtfulness that goes into it, it can really go off the rails. That's why I'm saying there's a lot of benefits, but there's a lot of risks as well.
Yeah, and we'll put a pin in that UPL discussion and come back to it. That'll be a fun, exciting closer.
Judge Schlegel, before we
please
move on
go.
to the next one,
Jump in
one of the
anytime.
other items I'm reminded of as I'm looking at my notes on this is how AI impacts essentially what we think about with sensitive personal information. As a data privacy attorney, we tend to think about risks in buckets, right? I got to organize my Lego pieces before I build my Lego. And so you have de-identified personal information. This is the category of information that has the least amount of risk. It's somebody who lives in Dublin. We don't know who it is. Then you have personal information. Now we know it's Mehmet living in Dublin, Ohio. We know his exact address. Then we have sensitive personal information. It's Mehmet's social security number. It is driver's license. It's also his biometric information. It's his precise geolocation information. We know that Mehmet is driving from Dublin, Ohio to downtown Columbus to work, and there are only so many people that do that every single day, right? Well, what happens now that you're able to take all this sensitive personal information, feed it into AI, you're able to create systems that you're able to use that you would not have been able to use before. Number one example that creates data privacy risks and as well as harms, in my mind, is facial recognition technology, which is inaccurate, especially when it comes to people of color and minorities. The software simply isn't good enough, and we've tried to make it better over time. We haven't, and it's caused risks over time. Rite Aid had an enforcement action against it by the Federal Trade Commission. They tried to use technology to find people who were shoplifting and who were causing ruckus, I guess, in their stores. And it turned out not to identify the people that they were supposed to. So what happens as a result? Well, employees follow you through the store, double check to make sure you're not stealing anything. Or they accost you. They ask you to leave in front of your family. Or they call the cops on you, right? You get arrested. Same kind of activity happens with automatic license plate readers. So you have people being pulled over, police out with their guns because they think the car is stolen, right? And all because the AI is inaccurate, or it's hallucinated, or it's not, it doesn't have the appropriate safeguards. Because once again, we're talking about a piece of technology, and technology can be used for good or evil, but if it's trained appropriately, and it's got the appropriate safeguards, and it's got appropriate governance, then it's less likely to have these errors and issues than if we were to let it run free on identifying individuals who may be selling stuff. The other item that I think that is likely to happen in the future that we don't think about all that much is essentially the amount of personal information and information that is available. I talked about de-identified information. Ordinarily, that kind of information is not regulated highly, or much if at all, in the law in the United States, right? Because you're unable to find the individual, which means you're unable to create harm for the individual. But you put enough data sets together, and that de-identified information eventually becomes identified personal information, especially so with precise geolocation information. So what if now you can take advertising data that all of us end up being subjected to on our phones, day in, day out, you combine enough data sets, now we know that we were all here today and we went back home, and on the way maybe stopped by Starbucks or whatever, right? And now you can identify wherever else you go, and what do you get out of that? You get corporate surveillance, you have privacy risks, or a state that essentially spies on its on its citizens. Or you could also have similar issues with respect to people being pulled over by the police, and now they're using facial recognition to recognize that individual. But what if they treat that, what the app says, as the truth with respect to that individual, and not what their ID says, or what their passport says, or what other government identification says? That creates risk. The individual goes to jail, they get detained for X amount of time, all because the technology isn't trained properly and it's not doing what it's supposed to do. I think those are the kind of civil liberties and other issues that AI ends up creating day in, day out that is also worthwhile highlighting.
Yeah, and I'm sure you've seen the reports of the firearm detection and the children getting called because they were carrying a firearm during school, but it was a cell phone or a banana in one case. So Kirsten, what type of concerns do you have about the increasing prevalence and usage of AI from the perspective of people with disabilities?
So jumping off on the privacy thing, because that is one of the concerns, is, there's a lot of potential tools out there, but to use them effectively, you might have to put a lot of information in there. Even if you de-identify it, like you said, enough of it can start to put that unique picture together. So, for example, one of my former board members described the disability service system, the healthcare system for people with disabilities, as something you almost needed a PhD to understand and navigate. And it's true, it is very complex. So you can see tools like generative AI tools helping with forms and things like that, and so can people with disabilities. That's a great possibility to help with getting insurance forms filled out, education access forms filled out, things like that. But in order to do that, you have to put a lot of private information. And even if you don't include your name, all that private medical information, once you compile enough of it, that's also privacy concern. So that was discussed, it's been discussed in a national study by AAPD, which is the American Association of People with Disabilities, that there's this privacy trade-off. To get access, you have to give up this information, but if you don't, then you're not going to get access. Not really a good choice there. So that was a concern. And then when I talked to advocates here in Ohio, and we talked about things like privacy, one of the things that they raised was, are there good, clear warnings? Are those warnings understandable, right? We talked about plain language. Do I really know what I'm giving up? And so that privacy concern then intersects with also accessibility as well as another concern area. And accessibility in general, obviously, which I'm going to talk more about that later, so I'm going to put a pin in that. But another concern from the Autistic Self-Advocacy Network is that, as we talked about with our panel earlier today, where we might try to take a tool and substitute it for that human lived experience or expertise, they're concerned about AI being sort of relied upon, whether it's by people with disabilities or by individuals writing something for people with disabilities to create plain language materials. Because plain language is not just reading level. And if you ask AI to create plain language for you or to create something for a certain reading level, they tend to then write it like it's for a child, not an adult with a developmental disability or intellectual disability or a neurodiverse disability that impacts their reading comprehension. And if you overlay that with legal information or healthcare or disability service information, now you've got terminology that matters, and that terminology, used custody as an example for the Somali language, but the same types of things can happen with plain language as the meaning changes. So it can be a fantastic tool for efficiency, right? If you have a person with lived experience that is practiced at doing plain language, like many of the advocates with ASAN are, or a professional that works in that field a lot that is also practiced at doing plain language, they could use it as a tool to get started or to check their work or to help them, but you can't really rely on it because of that. And add to that, the models themselves, there's not enough plain language information out there for them to have really learned how to write plain language. You mentioned, the difference between Spanish and Somali. It's like that, right? We just don't have enough of it, and so you can't really rely on it to get you that information as a starting point, like that complete rough draft. But you might be able to use it as a tool. But they have a lot of concerns about it being used as a substitute for that lived experience, and then also creating inaccurate, misleading information, or information that is paternalistic as well because of the way that it is presented.
Great. So Mehmet, with the balance that Kirsten just talked about, and kind of what you have to give to get out of these tools, do you think AI should be regulated, and if so, how? the smallest question you'll have today.
What a great question to ask to an attorney about what he thinks should be done in a particular area, and right after lunch, so I can put you all to sleep. So I think the way I'd answer that question is philosophically no, because I think regulation results in monopolies. Think about this in every single industry that is highly regulated. Power, water, sewers. How many competitors do you know in this particular area in any given space? Internet, right? These providers are highly regulated providers. They are utilities, right? And we increase the cost of entry to a marketplace whenever we highly regulate anything. And so from that perspective, given that we're living in a capitalist free market economy, you'd want to say, don't regulate this thing, right? So that it can roam free, it can create advantages for people, it can allow people to fill forms automatically in an accurate manner, right? And maybe translate things appropriately so they're not worried about their kids going to jail, right, instead of being in custody. But technically, I think, yeah, because there are a few things that the AI does that simply the law isn't necessarily designed to take care of. Now, I think we talked about it a little bit over lunch in the sense that before the introduction of AI, things that were illegal are still illegal today. You can't, for example, do something with AI that you weren't permitted to do beforehand, right? And the introduction of email, or the introduction of the internet, or the mobile phone, or social media, or AI doesn't change all these things. The law has been the law for some time. You can't take somebody's name and likeness and somehow create a video out of that and expect to make a profit. Somebody's gonna have a cause of action against you. You can't take a copyrighted piece of work and somehow use that to have it adapted to your style and somehow not have copyright infringements, right? We have all of these rights in the law already. And let me take a step back and talk about data privacy, data security regulation, and for good reason. People in data privacy, data security, we tend to think about the right of notice, transparency, accountability, right of access, deletion, correction, right to opt out. These are fundamental rights within data privacy. They've been with us since the 60s and 70s, and they're in pretty much all of the data privacy laws here in the United States that you can think about, whether it's GLBA from financial services, or HIPAA high-tech from healthcare purposes, right, or FERPA for education. They all rely on this concept of notice, access, correction, and related rights. But we don't necessarily have a law that creates that for AI, right? So you have to go and create it, and you say, hey, as an AI creator or somebody who's deploying this, you have an obligation to tell people that they're interacting with one. Right? That makes sense, because what happens years from now when you're unable to tell the difference between AI and a regular human being? Now, somebody who wants to break the law is going to continue to do that just because you told them they have to disclose it. They're not going to do that. Leave that aside, right? But in other usual public interchanges, I think the consumers have a right to know that they're dealing with AI, and they should be notified to them, and the laws are now coming into place to do that. That part of the regulation, I think, makes sense. One of the other things that I think we as a society should steer clear of are the lessons we kind of learned regulating the internet. When the internet first came to be, now I'm a child of the 80s, so I kind of remember it coming around, and those of you who are older will do the same, right? We created laws in this country that provided immunity to service providers. It's called the Communication Decency Act, Section 230. Essentially, I could go onto YouTube and post a defamatory statement about any other one of my panel members here. I don't know why I would, but assume I did, and they would have a right of action against me. Clearly, I've said something I'm supposed to say. I've defamed them. They could also sue Google as the owner of YouTube, and all YouTube would have to say is Section 230. I am not liable for your statements on this platform because I'm just making it available. And that's the kind of law that currently the AI providers are using to try to gain immunity and to say, I'm just a service provider. I am just saying what I'm told to say, or I should be provided immunity. Those arguments haven't really worked all well, and I think there are lessons to be learned from that, and I don't think we should go down the same route and provide immunity to somehow AI providers or deployers simply because there is more responsibility there. You're not just simply hosting a video that a user created. You're not just hosting a blog post that someone else created, right? You are a lot more involved in the output. And not just that, but more importantly, the training of the model, right? because of that amount of responsibility, I think even if Section 230 were to apply to AI developers or deployers, I don't think it should apply in the same manner. So from that perspective, maybe we don't provide them with the same immunities as we've done in the past with other kind of service providers when the internet came around in the mid-90s. But most certainly there are other items that we should look into. And I think the gold standard is something along the lines of where AI creates risks, we regulate, right? Where bias results in harm, you regulate. And if you really want to make millionaires out of plaintiffs' counsels, which I'm not, you create private causes of action. Nothing regulates the marketplace like a private cause of action. Everybody comes in line, right? Because you don't want to get sued for billions of dollars because you violated Illinois' Biometric Information Privacy Act, which is a thing that happens. So I think those are the kind of general ideas, guardrails that I think come to mind when we think about whether or not we should and how to go about doing it if we were doing that.
All right, well, I'm gonna come back to you in a little bit, and I want you to start thinking about world models and this notion of reasonable expectation of privacy in the world of AI wearables, and then we're gonna come back to your regulation discussion. But in the meantime, Susan, if you could build your dream world for Ohio legal help using AI, what would it look like? And then we'll dive right into the UPL issue.
Well, in my dream world, UPL could actually not UPL, sorry, it's on my brain. It's always on my brain.
Yeah.
And AI, by the way, is a really broad term. I think we're talking about generative AI
of course.
today.
Yep.
Yeah. In my perfect world, generative AI would actually be able to reason, think, and I guess bring in its own guardrails, right? Which it doesn't do now. I always say it's better now than the way it was before, right? When it first came on, it seemed like magic, but really all it did was fetch, come back, and it's a predictive algorithm, right? Better than before. Now it's a little bit better than that, but it's still not thinking, right? It's still not exercising discretion and trying to actually assist. It's fulfilling a task, a query that's being asked. It's going out and as my software engineer says, you know, uses like statistics and vector algebra. He's actually tried to explain this to me. I was like, please stop. And please just stop. I get it, it's an angle. And then it's really trying to use contextual information and statistics, and it's gonna bring you back the best fetch, right? Until like a couple years ago, if you asked AI, although the strawberry problem has been addressed, right? It wouldn't tell you how many hours came back, right? But it's not really thinking. And like when I've taught a class on this, I've said, don't think AI is really thinking right now. So in my perfect world, if we could, and you're really getting to a point where you're having an actual assistant next to you, it would be what I think some scholars would say we're getting close to, which is AI that is actually thinking and is logical, has ethics, is not showing bias, keeps your private secrets to yourself, you know, doesn't give you legal advice, but says, here are your options, here's how to exercise each of these options. You pick one with the good, and we're in Ohio, so local specific information that I've given you, right? You've put me out of business, but I'm okay, right? Because that would be a really good assistant. So I guess if you're asking me, in a perfect world, you're basically having a human on demand with great education, legal knowledge, ethics, privacy, good skills, can look at an Excel spreadsheet with 2,000 entries and organize it in a second, all at a cost of like nothing for folks who can't afford it, and at a relatively low cost for everybody else.
I gave you too much leeway. The question is, are you building a chatbot?
Wow. It would, my answer would be no.
No.
Yeah.
Why not?
You know, okay. Now you're going to really hear my bias.
Yep.
I think there has been a trend and a rush to build something called, they're called RAG chatbots, which means it's retrieval augmented generation. All that means is that you define, and this is a term of art, the knowledge base, right? And so you put in, but you're getting all the training with all the bias that Sherson's talking about with whatever commercial product, because People who say they're going to train their own, I hope they have lots of money. Yeah, so good luck with that. But you're using a commercial product. You're then saying tons of prompting, which is what it's called, to say, hey, don't make that mistake again. Don't hallucinate this. Only do this. And then it takes that and it retrieves information off your closed knowledge base, retrieves it, and serves it up to the public in a public chatbot. I hope you don't have a court chatbot. Do you ever? Okay, good. Don't want to be,
I started one. It didn't work out too well. I killed it immediately.
We actually built one, and then I was like, and because I don't think it's offering enough for the risk at hand. How about that? So I'm not a huge fan of chatbots. I think there has been a rush by not your court, but some courts to offer it, right? And I think there's also been a rush by legal services organizations, which I think it's a very poor substitute, by the way, for a good platform to do it, because it is the trend to do it. And because vendors have really come into this space, because they know how to just, it's like an assembly line. You can set them up, right? So I'm not a huge fan of a RAG chatbot. How about that?
Yep. No, it's great. It's there are some courts that have been able to do it successfully in a very narrow space, but it took a heck of a lot, to your point, a heck of a lot longer, years, not months, significant dollars, not pennies, and realize the challenges that you just expressed. And there's also the challenge of when the model changes underneath you that you built on top of it, and the model changes and you didn't know it, and that model's no longer available, that becomes an issue too.
And every query costs you money.
Yeah.
Yeah, we budgeted out, and we're like, we'll have to meter it. We would have metered them anyways, but we couldn't say, with all the volume that we have, probably 3 queries at a time, because every query costs you money.
So Kirsten, do you have any tips or best practices for ensuring accessibility for AI tools?
Yes. I mean, the biggest key, and there's actually the resource document that you're going to have has a little bit, some links you can go to. But I mean, the biggest key takeaway is that you need to include the people you're trying to provide this to, and that needs to include people with disabilities if it's a generally publicly available tool, right? We're talking at least 1 in 4 of every Americans either has or will have a disability at some point in their lifetime. That's a very large number, and too often things are built without thinking about accessibility on the front end, and retrofitting is difficult and not very successful and more costly on the back end. And speaking about regulated or not, there has not been, I mean, we do have the Americans with Disabilities Act, right? But it has not been as clear how that applies necessarily in the technology space. There's been some regulation and court legal guidance around websites, and there's more clear guidance for state and local governments under a recent Department of Justice rule about what has to apply. But that's just one, that's starting from the point of I'm a state or local government, or I'm a business, a public accommodation, and here are my obligations. The actual technology tools themselves, there's no requirements on them. So it becomes, the onus then is on the provider, whether it's the court, the law firm, the doctor's office, pick whatever one of those things you are, the higher education institution, they're the ones that have to provide accessibility. So one of the keys, obviously, is to, obviously for technology, want you to be thinking about how you're building it, but they're not the ones that are going to be held responsible. So then when you look at the people that are, you then have to be the one that asks those questions. So I think if you're thinking about all the other questions you have to ask when you're thinking about AI, right? Is it going to comply with my privacy requirements for my law firm or whatever the setting is? That's one question, but also ask, does it allow someone that uses a screen reader or other type of assistive technology to navigate it? Are the prompts going to be easily understandable by many types of individuals? Are there other, does it work with the other accessibility features that might be available in other forms of technology? So you need to ask those questions. And the best way, of course, is to include people with disabilities in your selection process. So if you have employees, or you can get a test group or another organization that can help you with testing something, or go to organizations to find out what are good options. Again, I put some resources in the handout for you to go to there as well. But when thinking about just some quick questions that you can start thinking about now, because when I mention things like the Web Accessibility Content Access Standards, or WCAG, people kind of zone out a little bit. And there are some easier to read versions of it, which you could use AI to go find. But just ask yourself just basic things, right? Is this something that a screen reader can navigate, or things properly tagged so that you can go through the flow of the document or the tool? If it creates images, is it adding alt text? And remember, going back to the model is only as good as the information it trains on. We talked about that with plain language. We talked about with other languages. We talked about with bias. Things are not very accessible right now. There was a study, I think, in 2023 where 97% of publicly available websites did not meet the WCAG standards. That's a lot, okay, right? So that's what things are training on. Right? They can't fix for accessibility. You can't rely on AI to fix the accessibility problem. You actually have to have people that know what they're doing. So I know that was sort of a lot to download on you all at once, but the main thing is involving people with disabilities if you can in the process. Think about accessibility at the front end. You are likely the one that's in the seat that's going to be responsible for complying with the ADA, so look for those accessibility requirements when you're bringing on a technology vendor. They don't necessarily have that applying to them, but you can keep them at that standard by being a good customer, basically, a customer that demands an accessible product, and that'll help make it better for everyone down the road. And then just as we talked about earlier with privacy, that's another thing. I know that is not necessarily quite the same thing as accessibility, but it is an important part of building something out that is going to be protect the information of the individuals you're working with, particularly thinking about warning people, right, about what they are potentially, that you're putting this into a format that could become public, so don't share this information, or even taking the extra steps to pull it out for them yourselves if you can. Those are things to think about as well.
And you had mentioned, websites, but is there something unique about Gen AI that courts and firms need to start thinking through of the requirements for accessibility?
I don't know that there have been accessibility standards that have been developed specific to that. So the website accessibility, those are the best sort of digital accessibility standards to kind of start from, because it can give you some of the same types of questions to ask and ways to look at, is the way this tool is operating, will it interact with the other things that it needs to interact with, right? Could you use a screen reader to get from A to B within the prompt and it makes sense to the user the way it's supposed to? I think that's why I analogize to that, because I'm not, and again, I don't really know anything about AI, guys. I did make that disclaimer before I came on this panel. I know about disability, so, but I am not aware of anything in the disability side, because again, it hasn't really been regulated, AI even that much, that is looking at AI specifically. Yeah. So you have to take from these other places and just try to bring those lessons forward. So what we have learned about accessibility generally, what we've learned about digital accessibility generally, we have to bring that into the building of AI tools. And at the end of the day, that is thinking about it at the front end. And vendors in that field should know about the digital accessibility standards under WCAG and be able to translate that into their tool if you raise it with them, right? So if you put accessibility on your sort of, here's the questions I have for someone before I bring a tool into my environment, then that will help to push the needle in the right direction.
And you make a great point when you say, I know nothing about AI, but you do, that's kind of the point of it, is you're an expert in your workflow, and that's how you actually can implement AI properly. So you're an expert, you're good. All right, Mehmet, we talk about a lot of these tools being biased. What is your take on that? And when somebody says that, what do you take it to mean?
We talked about this, once again, being a tool. We talked about the training. And ultimately, a large language model is a statistical model. And in statistics, the common saying is garbage in, garbage out, right? So if you fed garbage into your model, you can expect garbage to come out. And that's essentially what you have with respect to the bias that you've been getting in some of the examples that I've provided with respect to facial recognition, for example. We've had some other examples of this. None of them, I want to say, that have resulted in huge legal liability for a company other than, say, Rite Aid, as I mentioned, and the FTC enforcement action. And FTC enforcement action can be severe. It lasts for 20 years. It prevents you from doing X, Y, Z. You have to implement the data privacy, data security program. So to the extent that, once again, the FTC Section 5, which regulates deceptive unfair trade practices, you've violated, you're going to be stuck with that enforcement action for some time. But the FTC only has so many resources, right, to go after the bias that has harmed individuals in a particular area. We have other examples of this that are arguably less dollar sign attached from a legal perspective. Amazon back in the day, this has been some time, almost over a decade, but they decided they were going to try and automate their human resources and the job application regime by essentially training their AI on the resumes of people that have been accepted and the kind of people they like to employ, especially with respect to software and technical development, right? And surprisingly, who saw this coming, it started rejecting women. And women who had gone to women's colleges or women who were involved in women's sports. Guess what? The vast majority of the people that you employ in your workplace that happen to work on tech are men who are doing man things. And if you give the AI garbage, it's going to provide garbage in return. And so where that results, where the bias is in the data and in the training, that's what you're going to see in the output as well. And that, in some cases, ends up becoming employment discrimination, right? Now, I'm not an employment discrimination attorney, but I have a feeling you can't just straight up refuse employment to women or older people for this matter. Now, you would think this is just a limited area, but this is something that comes up often. There are at least 2 large lawsuits, one of them recently filed at the end of February against a company called Eightfold, and another one against Workday. Workday, you may be more familiar with it, which is a human resource information service provider. And both Eightfold and Workday essentially process employment applications. And thankfully, knock on wood, I haven't had to look for a job. It's been quite some time. I haven't gotten refusal letters, but I've heard quite a few nightmare stories about individuals applying for jobs and immediately, within minutes, getting rejection letters. How does that happen? How does that happen in the middle of the night? I mean, you're probably not, that HR professional is probably not looking at that. What is happening? The AI is rejecting your employment application. Is that legal? In some states, also, arguably not, right? Especially if it's discriminating against you and is biased against you. But what if, and that's the allegation in Eightfold's case, what if the software and the AI is taking information not just that you provided, but also collecting information from other sources? Where you applied from, what zip code you have, what your income may be, what your educational background may be, what other sites you've been to. And it creates a dossier, a profile about you, right? And it does all of this without telling you. I talked about transparency earlier. It's a very crucial, important aspect in data privacy and data security, and also now in AI, right? If you haven't been notified about the fact that all of this is happening in the background, how can you take action against it and say, I don't want this, right? If you have that right under applicable law, which you may if you're in some states, right, or if you're in Europe. So you're unable to see the biases, you're able to maybe see some of the impacts of it, but because you're an individual, you're unable to prove that the bias exists systemically, right? And I think therein lies one of the biggest issues that we have about AI, in the sense that it's provided to us in most cases as a black box. Just don't ask what's in it, don't ask how I came about making it work and all the IP infringements that I caused in the process. Just trust that it works, and if it doesn't, we'll train it and make it work for you. And so I think this is one of the crucial issues with respect to AI that we're currently seeing, that regulation is trying to address, at least from a state regulation perspective, and that we'll continue to see in the future. But I think the way around it is governance, right? With an experienced human being in the middle who understands what they're doing, so that they can try and reduce the harm. Well, how do you do that when you have somebody who's in a legal bind and they don't have the funds to be able to hire an attorney to do that? I am not sure that I have the answer for that, or as to how we address the bias there, short of, once again, testing it for bias. One other item I will add is, I talked quite a bit about bias. Technologists, when they see a problem, they create additional technology to address it, and they also point to attorneys and say, this sounds like a legal problem, you should solve it. And attorneys tend to point back and say, this sounds like a technology problem, maybe you should solve it. But there is technology out there that is intended to essentially test a large language model to see what the bias is and to see if it can be corrected. But technologies don't see, once again, you're trying to correct one statistical model with another statistical model. And it only works so well, and once again, the experienced human being doing the governance in the middle is the key to some of these bias issues.
Yeah, we're also seeing it in the insurance coverage decisions as well in seconds. Kirsten?
Well, I just wanted to add on to that because, I think sometimes when we hear the word bias, we're thinking of something that is intentional, that we're, excuse me, like calling out something in an intentionally discriminatory way. But it couldn't just simply be that this is historically how it is or that there's less of that information. It's training on the average, and people with disabilities, for example, are not within the average frequently, right? And many other groups that's the problem. And it's hard to train for that bias when really it's the human experience we've been living, and we don't even always recognize that it's there. I'm going to use a dirty word now, implicit bias, right? But it's real, it's a thing, and if we stop recognizing that exists, that's part of what we have here, and it's going to be very hard to correct for that with technology being created by people that have lived in a world where that just is, right? That's just the reality, and we're trying to move beyond it, but we're not there. So anyway, that's my little soapbox.
That's a good soapbox. It leads into that confirmation bias as well. So if you have your own implicit bias and you ask a bias tool a question in a certain way, it's going to confirm and answer in the way that it thinks you want it to answer so that you can say, good Claude, good Claude. Susan, let's get back to the UPL issue because I am dying to hear your opinion on the Nippon case and where you see the line, if there should be a line, as we build out these Gen AI tools.
So are folks familiar with the Nippon insurance case? It just got filed. It's a federal case. I'll give you a little background. So Nippon Insurance provides disability insurance, and there was an individual who they settled with, and everybody was, and she was represented at the time in the settlement. So they all signed off. Everyone thinks it's great. A year later, she's not happy with the settlement, and I'm picturing her at a computer, unhappy. She's got a little glass of wine next to her, and she's like, did I get gaslit by my attorney? And ChatGPT's like, tell me more. And boy, did she. And then ChatGPT told her, absolutely, they're so wrong, you've been gaslit, you go file. And actually, I'm not looking at transcripts, I'm making some of that up, sorry. But she did file. She filed a lot. And then that case got dismissed. She went back to ChatGPT. She filed again against someone else. And then, you know what? Brought in Nippon again. Let's just say like 50 pleadings later. By the way, case dismissed. Nippon's like, we have to be kind of the test plaintiff here. And so they sued ChatGPT. They did not sue her. They're suing ChatGPT for UPL, tortious interference, and one other claim. So it's going to be interesting to see how, to be fair, to see how all of it shakes out. But obviously, we're in particular interested in the UPL. First, I want to dispel a myth. Can technology commit UPL? You betcha. Yeah, I've been told this over and over and over again. We are an anonymous portal. Do I have user data? Sure. Do I share it with anyone? No, right? But people come to our portal, right? And they're seeking legal help. And for all the attorneys in this room, they really want you, but they get our platform, right? They want a human being to talk to, absolutely. But right now, Legal Services Corporation does this study every 4 or 5 years. 92% of the civil legal needs of low-income Americans, and Ohio reflects this, their needs go unmet for a number of reasons, including they just can't afford counsel. Also, the needs are so high, we can't lawyer ourselves out of this problem. So that's why I'm saying that technology has to be part of that solution, right? But those folks all come to our site, about 1 million visits a year, and they're looking for legal help, and really they're looking for legal advice. And I always tell them, no, 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 I'm going to give you good legal information, and sometimes for a specific county, I see. So I'm going to say Claremont County, so I'm going to point. And they want to know what's going on in Claremont County in probate court, and we tell them, the local rule's a little different there, beware of this, call the court, right? But here's the decisions you need to make, but we never make a decision for them. Do folks understand that if you pull a legal form for someone that's committing UPL in Ohio? Yep. And is UPL defined? Absolutely not. Judges know it when they see it. So,
we know all.
You do. Yeah, you do. You do, of course. So I need to work around these rules. Generally, the idea is that whether you're technology or a non-attorney, if you are in any way taking that set of facts, exercising discretion, and then telling someone what to do, you're giving legal advice. Okay? So I have told my staff this every single day. Our content team thinks about it. So if you actually come to our site, most folks come via Google. They've already said, I need this form. They come to our site, sometimes they get to the form, but that's their choice. They've searched for it. I'm not handing it to them, right? If you come through our homepage, you make selections at your discretion. They're all facts. You get a page about divorce in Ohio. I'm going to give you information that says if you have children, considerations. If you don't have children, then I'm going to give you the forms, dissolution, divorce with kids, divorce without kids. I don't select the form. You can. You select the form. But we're also careful. So if you get on our divorce without children document assembly, I just got to double check that you don't have kids, because folks don't sometimes understand what children of the marriage are. And so we'll do a little double check and saying, you know, you might have kids under Ohio law. Think about it. And then they make the choice. So we're always thinking about that. We're technology. I'm not having human interactions with them, right? But that I have to consider with UPL. Is ChatGPT committing UPL? I'm pretty sure it is. Yeah, because I've gotten it too. So there we go. If you ask it enough questions, it is more than glad to help you. And I will tell you, even though they've said they no longer do this, they still do, because it is hard baked into that black box of theirs. And if I ask it enough questions, because I have that higher tier account and I'm persistent enough, it's going to say, you should do this. So this is going to be an interesting case to watch, because I don't think any commission has brought a case against ChatGPT. I will tell you, and Tristan said something about plain language. ChatGPT scrapes my site and steals from me every single day. Google, because I can actually watch Google's scraping of my site. My site is we're in the thousands of pages. It comes and scrapes my site every single day, because it is taking training material. Do I have a big old copyright? You betcha. It's on there. Can I stop them? I could, actually, because we use Cloudflare, and I could stop them. But if I stop them, folks, they're going to stop referring folks to me. And so folks can't get to the good information. So I'm just saying, because I know Mehmet said something about, just because doesn't mean they're not doing illegal things. I think there's a lot that's going to happen in this area. UPL's one of them. What is copyright is being litigated right now. I just think it's going to be a really interesting area. And then one little comment. I'm a child of the 70s and then 80s, and then I guess a teenager of the 80s, or whatever you want to call it. But when the CDA came into place, they're really talking about, do folks even remember, I don't even remember this, but there were these bulletin boards that were on the internet, and people posted crap to it. That's what they were trying to protect folks from. Do folks even remember AOL or CompuServe? I mean, that's what they were trying to protect. We're not in that world anymore. So I think we need to carefully think about consumer harms and balance all this stuff as we think about this and we move forward.
So security, privacy, UPL. Mehmet, what are the best practices for designing a public-facing AI tool if a firm or a court or a legal help desk is interested in doing so?
Easy enough, just governance and putting the expert in the middle.
Oh, that's easy, right?
Yeah,
Yeah,
that's all it takes. As data privacy, data security, AI professionals, I think we tend to look at these as processes that don't really stop, and you need to be sure to implement the entire portion of the process and keep implementing it over and over. And it's the governance process, right? Yeah, I think it all starts with transparency. Once again, you need to ensure that whatever AI system is being provided to the public or your customers or whatever else, they're aware that they're interacting with one. I think there's a need to provide them with notice about what it does, what it's been trained on, and also the fact that it can get things wrong. It's not that it can get these wrong, it will get things wrong. That we use the technical word hallucination. We think about hallucination as what a human being does. Human beings most often do not hallucinate unless, once again, something is, they're having mental issues or they're on psychotic drugs. AI does this all the time without taking those things. And it's an important item to think about, it's an important item to disclose, and arguably an item that must be disclosed because that's what the law requires it to do so, right? The items regarding access become important because you have a data privacy right of access to your personal information. If the AI is being trained on your personal information, then you have a right to access that personal information and what it's being used for, who it's being sold to, what purposes it's being shared for. Those are the kind of items that you may want to disclose, and you arguably are required to disclose as a result of the data privacy laws that are in place throughout the United States and European Union. Those are all the items that I think you would want to implement, but something else to be said about data security as well. Another item that comes up often in the use of large language models is prompt injection. And essentially, every single time you're interacting with the AI, you are prompting it to do X, Y, Z. Fill out this form for me. You prompt AI long enough, sooner or later, you're able to make the AI access things it's not supposed to do or do the things that it's not supposed to do. As a result, you end up accessing unauthorized personal information, confidential information, or doing things that it's really not supposed to do, causing harm in the process, either for you or others. And that is a real possibility with any large language model. And I think what we're finding out essentially is that you have to manually place these controls in place for every scenario because the AI is designed to satisfy the user over and over again. And you don't have to ask it to, you just give it a task and it'll keep trying it and find ways to get to the end point, even if it means cheating to get there. And sometimes that's what they do. Right? They cheat the exam that they've been given so that they can get to the end results, but without answering all the questions that they were supposed to in the process. But all of this takes a process, resources, right? And right leadership and right policies. Having the right policies in place is crucial so that you can have the right governance process. And that starts with leaders at the top. If you fail to put an AI policy in place, you've put an AI policy in place. It's just whatever it is you want people to do. And so that's an important item to think about.
Great. So we are nearing the Q&A. Shearston, final thoughts, final words? Take your time. We got a few minutes.
I mean, I was just sitting here listening to what Susan and Mehmet were saying, and, you know, I guess a concern that I would still have is even all of these disclosures or ways of trying to interact with someone, is that going to be accessible, and not just the digital accessibility, but accessible from a language and cognition perspective, right? As we all know, I mean, all of us frequently check those boxes for terms and conditions for all kinds of things we do all the time. We don't even read them anymore, right? I worry that all of this stuff, which is great, right? Like, I don't disagree with anything you just said, but it's a lot. And it could lead to a list that then becomes meaningless for even us as lawyers, right? We don't want to read it. How is it going to be helpful to the average user? How is it going to be helpful to a person with a disability? So that's, I think, my final thought. And I think Mehmet wants to add on to that.
Yeah, definitely, if we have the time. I draft data privacy policies and terms of use on a daily basis. And I read what other companies post just so I can see what they're doing, so I can decide whether or not I want to implement them for my customers. But when I have to sign up for a service, I don't read that. Nobody does. They're not intended to be read. Terms of use and privacy policies are drafted for other attorneys and regulators. And it's just like that parking ticket you pick up behind which there are terms, or that cruise ticket, Carnival. I think there's a case law that went all the way up to the Supreme Court about this. Your cruise ticket has terms in the back of it, and those only become important when there is a lawsuit. And that's why they're drafted. So I don't think a consumer is intended to read, understand, waste all their time reading that thing. Don't. But realize that some attorney or some chatbot is drafting all those to cater to the interests of the company that wrote them. They're not there to protect your rights.
Susan?
Yeah, and I'm just going to add this. I got the best piece of advice from actually the privacy officer for Relics, who was very kind enough to draft our privacy policy pro bono. That's the beauty of being a nonprofit. You have fabulous people who are willing to help you. And then their privacy told me just one little bit of sage advice. Don't collect it. They basically said that. If you don't want it breached, if you don't need it, you should always ask yourself, do you need that bit of information, or is that to make someone feel good? If you don't need it, don't collect it. Don't keep it in your data. Tell them not to give it to you. Just don't collect it. And they said, just follow that rule. And I said, okay. And so my team always asks itself on court forums, and we push back with courts. We're like, why do you need that? Because if it's in our system, it can be breached. And I will tell you, we run end-to-end encryption, all sorts of stuff. I still don't want to collect it. So for the folks thinking about it, just remember that bit of sage advice. Don't collect it. Yeah.
And there should be a new regulation if there's a fight over terms of service, let the agents figure it out. All right, I think we're at time for questions. The judge is walking around. Questions? Got one in the back here?
I've got one
Or we got one right here?
I've got one close to me here.
Hi, David Corliss, Graphic Analytics. I'm a technologist, so I'm going to ask a question on a base in technology. We heard a lot about how AI should be regulated. My question jumps off of that, but it's more current state rather than future state. I teach classes on AI best practices for the American Statistical Association. One of the things I do, one piece of that class, is court decisions that are creating what I see as a de facto regulatory environment. When federal court decisions are making things like, you know, the Capital One data breach in 2019, they use product liability law to decide that. From my perspective, what I'm seeing is courts are using existing law to decide AI cases when they get to the courts. I want you to tell me what I'm getting wrong. We talked about how it should be regulated. How is it being regulated now? What is the process that you're seeing that actual courts are making to decide cases where there's AI being decided on?
So I think there are specific laws that apply to AI. So you have Colorado AI Act, which has been delayed until June of this year. It may or may not remain. You have the EU AI Act, which we're in the United States, we really don't care, other than the fact that it's going to influence how laws develop here. You have regulations in California that have been active since January 1, 2026 that apply to automated decision making and essentially automated decision making and profiling, and that's essentially AI regulation. And the California Privacy Protection Agency is the regulatory entity that enforces those regulations, is fairly active. It brings enforcement actions on data privacy issues regularly, and given that these regulations just kind of became active with respect to AI and automated decision making, those will be enforced. I don't want to say, that's not de facto law, that's actual law, right? It's regulation, it's been promulgated. Will it be tested in court? Sure, right? At the same time, while we have this, once again, AI-specific laws that have been passed, and those are just very few examples that I've described. There's New York dynamic pricing laws, et cetera, and Tennessee's disclosure law with respect to whether or not you're interacting with an AI agent. There are hundreds of these laws throughout the country that essentially tell you what to do, what you cannot do, right? And those are in place and you have to comply with them. And there are unrelated laws, as I've talked about. Copyright law has been around for hundreds of years. That isn't going to change simply because AI has come around. It's being applied to AI, right? And so it's an interpretation of existing law to new technology. Doesn't require new law, just requires a decision to say, yeah, copyright law hasn't changed just because you've created a new thing. I mean, you know, that's the beauty of the 50-state experiment that we have, and that's the beauty of the various courts that we have. Districts and circuits are going to disagree, and eventually, maybe someday, they'll be, you know, resolved in the Supreme Court. But it may not, right? And same issue with patentability and whether or not AI can patent things, right? And those are the kind of questions of fact, maybe, that end up becoming answers in law. Is that one way to put it? That's something that comes to mind. I'm not sure I have all the right answers here.
Yeah, and I was going to say, like, I think UDAP laws still apply. You know, I think ChatGPT is a supplier. But I don't think any of that area has been tested. I think also, obviously, under the Civil Rights Act, Title VII, the Amazon case, you know, how big data is being utilized to essentially bake in bias. I think Title VII exists. And I think Title VIII is going to be implicated as housing providers utilize, again, big data and AI to make housing decisions, right? That used to be what I used to do in a former life before my technology hat, right? So I think those laws still apply. I think the privacy laws would certainly apply. And I think the Federal Trade Commission obviously has a role in this, but so do state AGs, because, you know, when I was with the Attorney General's office, we had privacy as well, working often with the Federal Trade Commission. So I think there's direct consumer issues. I think there's the copyright, there's the privacy. I think the laws that exist on the books, just take AI out of it. If someone was using big data to say we're only going to hire men, I think that's a violation, right? Obviously, that's very specific, right? But intentionality is not what you need. That's just one area of civil rights, right? And so I think those laws that are on the books still exist to potentially rein in the uses that AI is being utilized for now. So, yeah.
And if you've been following all the federal work on this, they're attempting to pass a COSA-like legislation to preempt all state laws because, you know, they don't like all the states jumping in.
I'll expand on this state law versus federal law issue quite a bit because there's a bit of a tension. The Trump administration having passed some executive orders that essentially want to let AI run free and evolve and make money for everybody that's essentially working in it, and maybe help our lives become a little bit easier, right? So the repetitive tasks get easier to do. As a result of this, the Federal Trade Commission has an obligation to go back and review enforcement actions that aren't in line with the executive orders. And they've gone back and gotten rid of, at least dismissed one enforcement action they brought out during the Biden administration against a company called Ryder that wrote essentially fake reviews. You know, you go to Amazon, you want to buy something, and it's full of positive reviews. Oh, you'd love it. I'm going to buy that thing. And as it turns out, it's all been written by AI, and it's all positive, right? That's the FTC enforcement action that came into place that was dismissed as a result of the executive action. And so I am not sure how it's going to resolve itself. I think the states, as we were talking about earlier, attorneys general are very active in this area because attorneys general, AGs, are once again almost governors. They have political motives to be something else in the future, so they got to make names for themselves, right? So I think we'll continue to see enforcement actions in that area, for right or wrong, and then we'll see federal laws, probably not anytime soon. I don't see it happening, to be honest with you. Either, whether in data privacy, data security, or AI regulation from a federal perspective, I don't see that happening soon. So we'll have this split for some time. As to the Federal Trade Commission suing a state to, you know, not enforce a law on the books, who knows? These are, you know, different times we're living in.
We have another question here.
You kind of answered my question a little bit, but I was wondering how might the lack of a national legal framework render us less prepared to handle AI issues? For example, the EU has passed an AI Act. We don't have a national law in this country yet. So how might that impact our ability to handle AI issues as they arise and make us more reliant on a patchwork of state policies?
I'll take a stab at that.
That's you,
okay.
Mehmet.
Yeah.
That's why you're here.
Right.
Go.
I think it's great for attorneys because you know you get the bill by the hour to explain all these various laws to your clients. So from that perspective, I don't feel like I'm going to suffer. But are we required to have that? I talked about the beautiful 50-state experiment. We've always had that, right? And we rarely have the same exact laws in every single state. Susan mentioned you'd have the unfair deceptive acts and practices that essentially at mini FTCs that we have throughout the country. Those things that were illegal, once again, will remain illegal. And we will continue to enforce them. When I say we, plaintiffs' attorneys will continue to enforce them against companies or people who are harming consumers or others by using existing law. I think the lack of a uniform direction creates some ambiguity for those of us that are implementing the AI and trying to comply with applicable laws. But I think it's definitely a positive from a technology and supporting technology to get better and to advance advancements. And the EU, as a result of that, is taking a look at AI Act and determining, well, is that really what we wanted to do? Is this stopping innovation? And is that the reason why our economy isn't growing as much as the United States is? Let's face it, AI is one of the primary reasons why the economy is being propped up right now, right? So I don't necessarily see that as a huge issue from a legal perspective. And most technologists, and once again, most of the AI companies would say, yes, let's have a federal law that preempts all state law, so it's easy to comply with, and it's also just complex enough that it creates a bar, and once again, regulation creates monopolies. So now entrance to the marketplace is a little bit difficult. It's just the way things we've been doing it. Maybe I don't know a better way to do it. That's why I'm suggesting it's good enough.
Kirsten?
I'm going to do a little interpretive license on answering this.
Do it.
So you had mentioned a couple questions back, actually, something about private causes of action being a great way to, in a way, regulate or at least enforce rights. And I don't necessarily disagree with that, but in thinking about this question and what you were saying about the different states and the laws and enforcing them, you have to have a private cause of action with meaningful remedies. And so, for example, in the area of a disability, Title III, the ADA, which applies to those public accommodations, so not the state and local governments, but the businesses, the law firms, the doctor's offices, the insurance companies, guess what? You don't get damages. You don't get attorney's fees. What's the meaningful remedy there, right? So, and there's been an effort at doing things like that at the state level too. So I just throw that out there for a group that cares about access to justice, that, maybe we don't need to build up an extensive amount of regulation. Maybe it's okay to rely on our existing laws, but we got to make sure that we don't take away from those where there is enforcement at that level, and potentially consider increasing at least the tools that are available to the end user with the laws that we have.
All right, and with that, I ask you to help me thank Kirsten, Mehmet, and Susan.
I think you can join me in thanking them again for walking us through a pretty good dialogue in AI in the public sphere. And at this point, we are getting ready for a pretty interesting public demonstration right now. We are going to bring some legal technology to life here. This presentation you're about to see was created by Sadie Moore, Susan Choe, Jay Wampler, and an AI bot. We want to offer a special thank you to Verbit for providing the technology behind this demonstration, and we are about to see who can analyze this data faster. So please join us for a live demonstration.
Well, what a phenomenal day. We wanted to do something unique as a thank you to everyone and to keep everyone thinking about AI's reach in our day-to-day legal lives. So we partnered with Verbit. Verbit is a legal technology company that focuses on real live time transcription with item tracking, active inconsistency citations, and summarizations. So we will be presenting a deposition segment from an authentic case utilizing Verbit's AI-powered platform. Susan will be our attorney and Jay our deponent. Susan will run Verbit on her laptop, which is displayed up on the screen. Thank you. And we will watch on the left side of the screen when we begin, you will see a transcript of what they're saying populate in real time. You will then see on the right-hand side a number of categories. We'll talk about those a little bit later, but you will watch as different colored dots show up next to them, and those categories are item tracking, inconsistencies, short summary, detailed summary, and narrative summary. So while the depo is taking place and you're putting it together, we'll see how AI puts everything together. So Matan, I will wait for a moment while Matan from Verbit will help us with beginning.
Good morning, Mr. Harbaugh. I know I introduced myself off the record. My name is Vin Green, and I'm going to be asking you most of the questions here this morning.
Okay.
First, I know I asked you this earlier, but can you hear me okay?
I can hear you fine. Yes, great.
Okay. Mr. Harbaugh, could you just state your full name for the record?
Yeah, Matthew Kohler Harbaugh.
Okay. Then I want to go over just a few ground rules. As you heard the court reporter, the videographer say earlier, there's a little delay here. And there is a court reporter taking down everything we say. So if you let me finish my question before your answer and try to take account of the delay in the video, I'd appreciate that, okay?
You bet.
Okay, and so what was your position at Covidian when you started in August of 2007?
I was the Vice President of Finance and Controller for the Imaging Solutions business.
And so in about June of 2008, did you become the Chief Financial Officer and Vice President for Global Finance and Shared Services of Covidian?
Of Covidian Pharmaceuticals? Yes, okay. Not Covidian. That would have been my boss, the CFO of the entire enterprise.
Now, in approximately 2013, Covidian spun off its Covidian Pharma division. Is that correct?
Yes, in June of 2013.
When did discussions begin at Covidian concerning spinning off Covidian Pharma?
You'd have to ask the parent or the board members because I wasn't in those conversations. What I understand is somewhere around August or September of 2011, the CEO of Covidian called me to let me know what their plan was. And the reason he called me was he wanted to understand what that meant for my career. And it was announced and I may be fuzzy on the timing here, but I believe it was announced in December of 2011 publicly that that was the intention.
At that point that you received that phone call, were you provided any information as to why Covidian wanted to spin off its pharma division?
Well, the only thing that I knew is we had a number of discussions with other companies, and I don't think they got an offer that they found acceptable. But I wasn't really in that. That would have been a board decision.
And so from 2011 on, was it your understanding that your shepherding of the Covidian Pharma division was for the purpose of spinning it off?
No. From November of 2010 through, to call it the summer of 2011, maybe late spring, They were still looking for a sale. I wasn't in the loop on any sort of bids or where the discussions went. That was all handled at corporate. I was only involved in some of the time due diligence process that they had going on. And I would not have done that work. That work would have been done by the parent. I was there to be the CFO and shepherd the business. And I said earlier, my parent would have made the decision with the board as to what they wanted to do with Mallinckrodt. And frankly, I think they rightly so largely kept me in the dark because all they wanted me to do was to kind of keep the business on track.
Do you have an understanding as to why the Covidian parent company decided to spin off the pharma division?
The only thing... The only thing I seem to recall is they didn't get the valuation that they were hoping for, and the board decided that they still wanted to transition the pharmaceutical business out, and they made the decision to spin it out. But again, I wasn't in the room for those discussions. I would have been on the fringe of this. They were hoping to get X amount of dollars for the business, and they didn't get a bid that met their needs. And in the end, they decided strategically that pharmaceuticals was not a fit for the company long term.
Would you agree with me that when the pharma division was spun off, that all the assets and liabilities of that division went with the new entity?
Yes, the assets that were associated with the pharmaceutical business went with what became Mallinckrodt PLLC.
So let's break here, and let's take a look at what AI has been up to. Now, at a certain point, you may have noticed that we had the speakers populate. Before it was, red dot, red dot, red dot, and then all of a sudden, we see that Matthew Harbaugh is identified as one of the speakers, and the attorney is identified as the other speaker. This provides us a transcript in real time that also allows for us to have it before the certified transcript comes in for purposes of beginning our motion drafting. It's a wonderful tool. We also, I had indicated to pay attention on the right-hand side. If you see the category item tracking, here's where the AI also came into play. Prior to the deposition, Susan would have fed in an outline for the deposition. That would be uploaded, and then the AI, through the item tracking, is tracking the outline and the progress that has been made in each of the areas of that outline. And so you will have seen through the scrolling here that some of the items had been achieved, some of the items were not achieved, and some were partially achieved. For those partially achieved, we can then see what are the components that were achieved and what were not. You're also seeing hovering over sections of the transcript. You can very easily on a break be able to go and review the transcript in the various areas to see what in fact is missing and what is not. So the item tracking becomes a wonderful function for the practitioner as you're going through. I know for myself, in my as I age, sometimes it's hard to keep up, and you have that senior moment, right? As I did earlier today. With the item tracking, it's a wonderful opportunity to have support live so that you can get to everything you need to with that witness. Inconsistencies. So, within this case file, what has happened prior to the deposition is all of the case evidence has been uploaded into the system. That means any prior testimony, transcripts, document production, interrogatory answers, you name it, it's up in there. As the witness testifies, the inconsistencies populates with every place in the uploaded documents that conflict with what is being said by the witness. In addition, it will analyze the witness's testimony and be able to identify inconsistencies that the witness himself has during the deposition. A very, very powerful tool that allows you to not only see the inconsistency in real time, but also allows you to immediately access the documents and the places in the record that you've uploaded where the conflicts exist, and thereby be able to pull that up and utilize that within the deposition in real time. In addition, you see the short summary tab. So some clients want to know what the heck is going on right now, right? And how nice it is that during a break, you can literally go to a short summary and do a copy-paste job over to the client to say, here's where we're at. Or to a colleague to say, listen, take a look at this. I'd like you to take a look at X, Y, and Z. And if they are able to identify something that you need to get uploaded in, you do that as well. So a wonderful tool to utilize in client communications and with colleagues who are not present at the deposition. Verbit can also be accessed off-site by your colleagues to follow along as you're going through it. So the detailed summary, you get to the end of the deposition, or you're taking a look later on for purposes of motion drafting. It categorizes the deposition and provides a detailed summary within that outline of everything that's happened. And then we have the narrative summary, which provides a high-level conversational type summary with respect to the deposition and what's occurred. And Susan, wanted to get your thoughts on what it was like using the AI-powered platform.
Well, first, full disclosure, I don't litigate anymore, but I think I'm just thinking through, so, I started practice in the late 90s and clerking, and I remember thinking through, oh, we did 32 depositions in this case, right? And they had to be hand-indexed and reviewed, and just this kind of tool would have just saved a ton of time. But for all the attorneys out there, this doesn't replace you. This just makes you more effective. This just makes you, better at a better use of your time. So I think I'm going to echo everybody else that if I were litigating today, I would probably utilize AI as something to help me, but it doesn't necessarily replace my good thinking, because there's still, even with this platform, there's a lot of work that I had to do, right? I had to think of the outline. I had to think what are the elements. And so, I think, but having a tool, and I'm not saying Verbit, because in full disclosure, I can't endorse anything, right? But I think having a tool like this can be tremendously helpful as a litigator.
Jay?
Yeah, I first of all would also disclaim that our office, can't endorse a particular product, but I'm going to attack this. Everybody in the room is thinking about whether you could use it or not, but something that Kirsten shared in her presentation, most of you don't realize that I'm actually deaf and hard of hearing. So if you're in that circumstance, or if you have that, this is also a tool that can be assisting in other manners and in other ways. So whether I'm, in chambers reviewing something, right? If you happen to be a judge, and you would be going through things, and this could be this might be the version of the transcript you got. So understanding, if I'm a judge, that this could be the way that it's traveling now, and you could see more breaks coming out because of inconsistencies. Whether I'm a solo practitioner or whether I'm in a bigger law firm and doing deposition work, obviously this tool can be very good. I think the biggest benefit is that you see this is an example of AI, and I think to me that's the part that this is where AI might be, but now keep in mind that in my particular circumstances of life of someone who's deaf and hard of hearing, this is very helpful for me to be able to see right along just in case I missed something, right?
So just in case I might have missed something. So that doesn't apply to everybody, but I just want to continue to throw that out there, that there are different ways that this could impact. And that was one of the first things when I was asked to participate in this portion that really stood out to me.
Thank you. We do want to thank our partner who helped us in putting this together, and that's Verbit. And there are some representatives here with us, Matan to the right, who was instrumental in helping us put the script together and do the dry runs and so forth, and Chris, his colleague, who's here as well. Both of them are here to answer any questions you may have about the technology, because certainly we don't have that information, but they do. Did I cover all of those categories? Good? Okay. So we would like to have some questions here. We've got a couple minutes, and we'll see what we can do.
Anyone?
Sorry, but this one at least is a quick question. Non-speakers of English, or people who don't speak English very well, they're very heavily accented, or if someone is speaking in another language. Thank you.
Yes, with respect to other languages, Chris, Matan, would one of you like to address that?
50+ languages for transcription and translations. As you can hear by my accent, it actually know how to transcribe everything that I'm saying as well. We also have like a multilingual models that know how to identify the languages in real time, if you're speaking, I don't know, Spanish and English at the same time.
Any other questions? Right up front.
Is this a product that you need to have an annual subscription for, or if you just happen to litigate occasionally, you can get it for a one-time use?
Yeah, thank you. No, good question. Yeah, we have a couple different models that we use. So we can use a subscription. We have some firms that we have, firm-wide adoption, some that might have a practice area adoption. But if you use it on a case-by-case basis, we can also do it, basically per minute and then charge you per that. So you don't have to do a firm-wide enterprise deal if you don't want.
So with that, unless we have any other questions, we want to thank you for your attention and for joining us on this little ride on the screen. We hope it was helpful in you seeing where technology is in practicality and what the future may hold. Thank you.
That was absolutely fascinating. Thank you very much for letting all of us witness that in real time and see what some of these tools can look like, ways they can help us that may be different than we thought before this morning. Otherwise, this, my friends, concludes our official programming today. I want to thank again all of our presenters and our sponsors for making today possible. I want to thank all of you for coming out today and sharing this time with us, for being part of this ongoing conversation. I hope you're all feeling like we're leaving today with a little different lens into the many layers of this conversation around the role AI is going to play in the legal system. I hope you're all feeling inspired to maybe try a few tools you hadn't tried, learn a few things you might have been resisting a little bit. I also just hope that all of you have enjoyed spending the day with us here at the Ohio State Bar Foundation. We'd love to have all of you stay engaged with us in many ways. You can make an investment in our mission. You can join our Fellows program. You got a chance today to see and hear from a few pretty brilliant folks who have gone through the OSBF Fellows program, so consider that yourself. Consider nominating some folks from your firm or your office to go through the program. I hope you all know that one of the other things we're really proud of is our statewide award program, where we really shine a light on attorneys who are just pillars of the civic life in Ohio, so we hope you'll consider nominating someone for that. And also explore our grants program. Our board president, Mr. Hollingsworth, was kind of proudly touting to all of us, we have invested $19 million in Ohio nonprofits and are just getting started. So hope that all of you will take a look at potentially having some of the nonprofits that you work with to really help expand this legal sphere here in Ohio to submit a proposal. Otherwise, just stay engaged with us, stay informed. One last time, for those of you who are interested in receiving the CLE credits, please return your form to those 2 registration tables right before you leave. The activity code is 610984. That's 610984. And we also would love it if all of you would just take a minute to offer us a little feedback about today's program. We're enjoying having you here and would love to hear what you thought of this and how we might kind of expand on this in the future. Otherwise, I thank you all so much for spending the day with us, and I'm excited to continue the conversation with all of you. Safe travels.